Here's a great question from the Illinois Divorce Support Network, our private Facebook group about 401ks and divorce. The question is, 401k question, if I have every 401k statement and had an analysis of growth performed, would the earnings on the premarital contributions be considered marital property? That's a great question, and the answer is no. If you have every statement going back to the date of the marriage, then an expert can determine exactly how much growth came from the premarital contributions versus the growth from the marital contributions, and can separate that out so you have a very exact accounting of what should be marital and therefore divided with your spouse in a divorce, and what should be non-marital, and you would keep that. Most people don't have all those statements, so what ends up happening is the court divides the pension, the marital portion of the pension, using what is known as the Hunt formula, like hunting. It's a case called Marriage of Hunt in Illinois from many years ago, where the court was dividing a plan like that. In this case, a 401k can also be done with a pension. And all they do is they take the years of the marriage divided by the years of contribution to the plan to figure out the marital portion. It's really sort of a rough cut or an estimate. So it's not as precise as having all the statements, but very few people have all the statements. So when you don't have all the statements, let's say you have a 20 years of contribution and a 10-year marriage, half of the 401k will be marital, subject to division, and in a generic 50-50 division case, half of that would go to the other person, so 25% of the entire plan. So that's how that works. Thanks for asking the question. Please keep those questions coming. I'm STG Divorce Law's managing partner in Chicago, and your divorce lawyer, Rayford Dalton Palmer.